my part is on identifying and addressing estate planning issues for the T and Q of the LGBTQ community. And I know a number of people may be asking, why are we looking at a minority of a minority? And in addition to what Chris said, this is a very complex issue. Recent studies have indicated that there are more than 1 million transgender persons in the United States. And as we all know, that's a vulnerable community, and when you're coming out, you're kind of reticent about doing so. So I think that number is actually low. And that is just the transgender community. That doesn't even include queer persons. So again, the number 1 million is low. But that number is still big. 1 million people is a lot of people. And we need to be concerned and address those issues. The other reason why it's important is because transgender and queer rights involve the second cornerstone of the marriage equality movement. The first, of course, being relationship rights. The second cornerstone being gender rights. And so we have to embrace this knowledge and use this knowledge in representing our clients. How do we start this intake conversation? Well, we go back to the 70s, the first feminist movement, where sensitive people asked a woman, what would you like to be called? How am I to address you? Because some married women preferred Ms. to Mrs. Some single women preferred Ms. to Miss. So we asked Dana, is there a way you would like to be addressed? We cannot presume the pronouns, and we cannot presume how they self-identify. Simply ask. That will move the conversation forward. That will take the dialogue and planning process into a very respectful and safe zone. Section 5 of the Civil Union Act contains no gender. No gender language, no biological marker. But if we go to Section 10, we see that persons entering into an Illinois Civil Union Act have to be male or female, either same sex or opposite, male or female. What if your client doesn't want to check a box? How do we deal with that? Now, Section 5 is to be liberally construed, but I contend, as we lawyers all know, that in order to satisfy a statute, in order to satisfy something granting rights, we have to be able to meet the definitions in that statute. It is not gender neutral. And so while Windsor was indeed and is indeed a watershed case for same-sex couples, it left gaps and traps for transgender and queer couples. So I'm going to come back from Windsor and come to Illinois, which I was very pleased to see the language in our Marriage Fairness Act, because it embraces the entire community. Our second equality statute, marriage equality statute, states that the underlying purpose is to provide same-sex and different sex couples and their children equal access to status, benefits, rights, protections, and responsibilities of a civil marriage. Now, some people may say, well, different is opposite. No. Different contains opposite, but it does not necessarily mean opposite. So what does this mean? As Richard talked about, there was a flurry of activity after Windsor, especially with respect to the IRS. And the IRS did, in fact, issue Revenue Ruling 2013-17. And in its ruling, it stated the IRS never thought about gender. I think there was a case back in 1955 where it mentioned sexual marker. And that was the last time the IRS ever really thought about gender. So, all right, we will, and the holding was relatively narrow, but the IRS, as a federal agency, took it one step further, said we will treat all lawfully married couples the same with respect to not just estate taxes, but with respect to gift taxes, income taxes, all tax treatment. All lawful married couples, all tax treatment, same treatment. The other thing is that the IRS mandated that it would use the standard of place of celebration as opposed to place of domicile in determining whether or not a marriage was lawful. And finally, it suggested that all other agencies do the same, especially if they derive their benefits from the Internal Revenue Code. But there were a number of agencies that refused to recognize same-sex marriage initially, and of course they had to abide by the Windsor decision, but they didn't necessarily have to follow the IRS completely. And I think most lawyers and most of us would agree that it's the non-financial considerations that are thornier. It's the family dynamics that we have to get around. And once we get around all of that, then the financial considerations are a little bit easier. So I'm going to talk just briefly about the non-financial estate planning conversations that we should have with our clients. There are three, basically, involving your health, the client's health, health of loved ones, family dynamics, as I mentioned, and lifestyle, particularly relocation, mobility, and retirement goals. Now, beginning with health, we all want good health. Everybody wants good health. Transgender and queer persons are no different. And we need to also understand this disclaimer. Not all transgender persons want to or will undergo sexual reconstruction. So that might be a moot issue. It might be a non-issue. But we still have to ask. Another critical query is whether or not our client is seeing a psychotherapist. Because if the client is seeing a psychotherapist, that information and all of the key trusted advisors need to be placed on all of the advanced directives. And these documents may be the most very important documents in that estate plan. And they need to be much more than the basic power of attorney that one can grab offline. Let's go into family dynamics, and I think we can all agree that family battles make estate planning sexy. We don't like it, but it does. Forget Zuckerberg. He's protected and happy. Give me Philip Seymour Hoffman anytime. May he rest in peace. We don't like the contention. And resolving family contentions in estate planning involving same-sex couples now, and especially in friendly jurisdictions, and heteronormative married couples now, is a relatively settled issue. There's settled case law. There are judges who understand and have experience with the dynamics. Not so for transgender and queer persons. The case law is just now starting. Judges are just now seeing these things. So it's important that we understand that we are the key line, the key defense line for these parties. And so we have to also understand then who those key players are. And so instead of, estate planning attorneys, we love to draw. So we get out and we start drawing these flow charts, and they look lovely. But I contend that we should draw Venn diagrams instead. And your Venn diagrams help you to separate the good guys from the bad guys, like Darth and the Dark Force. And you can really see where that bridge or that wall needs to be created. And then spell out, what are we given permission to say? When are we given permission to say it? And to whom? Does Dana want her mother-in-law to know that she was born male? Does Dana want her stepchildren to know? Does Dana want her employer to know? Is it her employer's business? We have to be really careful about the information we can share. We met Dana at her therapist's office. We're trying to create this estate plan, and we have some questions about health. Can we phone the therapist and ask where Dana sits on the sexual reconstruction timeline? When will Dana be finished? No, we cannot. We can't. And that doctor should not tell us.